to another exciting presentation by Dean Erwin Chemerinsky. The Supreme Court has not slowed down a bit, and I depend on him to keep up with it for all of us. My name is Bill Sokol. I'm here simply to introduce Dean Chemerinsky. I'll be brief, Dean Chemerinsky, because everybody knows all about you here at OLLI. You're one of our dear friends now. He is the Dean of the Berkeley School of Law. He's just finished up a year as the President of the American Association of Law Schools. If I have it right, he's going to tell us about his 14th book. He is the most quoted constitutional law scholar in the country now, and I consider him our premier constitutional law scholar and interpreter. And it's a huge pleasure to have him here today to talk about his new book. I hope this doesn't show up backwards. The name of the book is Presumed Guilty: How the Supreme Court Empowered the Police and Subverted Civil Rights. Dean Chemerinsky heard that and he got out of a chair and walked away. Okay. I want you, Dean Chemerinsky, if you're good enough, what's your time today? How long do you want to talk? How much in the way of questioning?
That's entirely up to you. My suggestion would be to talk for about an hour and 30 minutes of questions. But if you prefer I talk less and take more of questions, I'll do whatever you want.
Oh, no, I'd like to say, how about 12-hour talk, 12 hours of questions? No, an hour plus 30 would be magnificent. That'd be great. And I would encourage people, as questions come to mind, please do put them in the chat area. Just put your question down. So then when we take the break for the questions, we have them in the chat zone and I can just shoot them to Dean Chemerinsky. With that, Dean Chemerinsky, the screen is yours.
Thank you. Thank you for the kind introduction. Speaking for OLLI is always a great pleasure. It is a momentous time in the Supreme Court. As you know, the Supreme Court heard oral arguments on December 1st as to a case as to whether to overrule Roe versus Wade. That will be decided by the end of June. And the Supreme Court just this morning granted 2 cases to be heard next October on whether to overrule prior decisions that allowed affirmative action by colleges and universities. I could give many examples of things now pending before the Supreme Court that are likely to bring about a dramatic change in the law. And I am glad during the question and answer period to talk about any of those cases. But you were kind enough to invite me to talk today about a different aspect of Supreme Court jurisprudence, about the Supreme Court and the police. And this is the focus of a new book that came out in the fall titled Presumed Guilty: How the Supreme Court Empowered the Police and Subverted Civil Rights. The death of George Floyd focused national attention on the problem of policing. But I don't think there's been sufficient attention paid to the role of the Supreme Court and to the problems of policing and racialized policing in the United States. Everyone on this call is familiar with the extent to which there is racialized policing in the United States. The statistics are stunning. That's what I reached for a moment ago. So I can provide you some of those statistics. In 2016, Black males between 15 and 34 were 9 times more likely than other Americans to be killed by law enforcement officers. They're killed at 4 times the rate of young white men. Hispanic men are nearly twice as likely to be killed by police as white men. The United States Civil Rights Commission concluded that while people of color make up fewer than 38% of the population, they make up about 63% of unarmed people killed by police. If you look at police stops in every city, police are much more likely to stop people of color than white people, holding all other variables constant. Because of where we are, let me talk about the Bay Area. A study of the San Francisco Police Department found that while African Americans make up 15% of the population, there are more than 42% of those who are stopped by the police. I can show you similar statistics from Los Angeles, from New York, from smaller cities like Greensboro, North Carolina, and the like. What I wanted to do in this book is to tell the story of how the Supreme Court has contributed to and is even responsible for some of the problems with regard to policing, police violence in the United States. I intentionally chose to begin the book with a story of a Supreme Court case from 40 years ago, City of Los Angeles versus Lyons. It involved a 24-year-old Black man in Los Angeles, Adolph Lyons, who was stopped by the police for driving with a burned out taillight. Lyons was ordered out of his car. The officer slammed Lyons' hands above his head onto the roof of the car. Lyons complained that the keys that he was holding were cutting into the skin of his palm. The officer then administered a chokehold on Lyons and rendered him unconscious. Lyons awoke. He was spitting blood and dirt. He had urinated and defecated. The officer gave Lyons a traffic ticket and let him go. Lyons did some research. He discovered at that point 16 people in Los Angeles had died from police use of the chokehold, almost all like him, Black men. Lyons sued the city of Los Angeles for an injunction to stop police from using the chokehold, except if necessary to protect the officer's life or safety. The Supreme Court ruled 5-4 that Lyons' case had to be dismissed. Justice Byron White wrote for the majority. He said that Lyons could not show that he personally was likely to be stopped by the police in the future and choked again. The court said a plaintiff like Lyons, who's seeking an injunction, must show a likelihood of future personal injury. Justice Thurgood Marshall wrote for the 4 dissenters. He pointed out that this requirement would mean that no one likely ever could sue to stop the use of the police chokehold, because no person is ever going to be able to show that it's going to happen to him or her in the future. Justice Marshall said there are many police practices and government practices where we know it's going to affect someone in the future, but we can never know who it's going to be. And Justice Marshall said this is going to preclude all of these cases from being heard in federal court. And Justice Marshall was right. No one, of course, was ever able to bring the suit challenging the legality of the chokehold. If the Supreme Court had declared the chokehold unconstitutional in 1982, perhaps Eric Garner and George Floyd and many others who died from it would still be alive. But it's not just about the chokehold. There were a couple of lower federal court cases that involved women who were stopped by police officers for routine traffic infractions. And they were subjected to very degrading strip searches. And they sued the cities for the police departments to be forced to stop having police officers do strip searches and humiliating, degrading practice when it was a routine traffic stop. And the lower federal court said the women could not show that they personally were likely to be stopped and strip searched in the future, so they couldn't sue for an injunction. I've been part of so many conversations where people have wanted to stop an abusive police practice, but they could never be able to show who would be subjected to it in the future, even though we knew that it was a practice that would affect people, so no one could sue. And of course, this isn't just about suing the police. It's about any government practice. If someone wants an injunction, they have to show he or she is likely to be sued in the future. Why did I choose to start the book with the story of Adolph Lyons? Some of it is because it's a compelling illustration of the failure of the Supreme Court to control the police. Some of it is, it's not a story that's familiar to most people. It's about a relatively technical aspect of the law, who has standing to sue in federal court. Also, it tells you a little bit about the story of my writing this book and when I wrote it. After teaching criminal procedure to law students in the fall of 2019, I decided I want to write a book about how the Supreme Court had empowered the police. And I did a book proposal, and my wonderful literary agent, Bonnie Nadell, found a terrific publisher, Norton and the imprint Library, that wanted to publish it. And I signed the contract in January of 2020. And my expectation was that I would take, it's usually a year or two, and write the book. In early June of 2020, my editor, Bob Weil, called me and said, "How soon can you get me the manuscript?" This, of course, was after the death of George Floyd. And I very quickly finished the manuscript between the beginning of June and turned it in at the end of October of 2020. And the death of George Floyd was very much in mind. The death of George Floyd because of choking by a police officer. And I thought this would therefore be an important example with which to begin the book. I decided what I wanted to do was tell the story of the Supreme Court and policing in the United States chronologically. And so an early part of the book talks about from the time the Constitution and its amendments were adopted until basically the 20th century, or even well into the 20th century, and how the Supreme Court during this time, especially the 19th century, decided almost no cases about policing. A word of explanation. There are a number of provisions of the Bill of Rights that are meant to limit what law enforcement can do. Most obviously, the Fourth Amendment that limits searches and arrests is meant to limit what the police can do. It says that the police can only search someone or seize, stop, arrest someone if there's probable cause, and there generally has to be a warrant. The Fifth Amendment, among other things, protects the privilege against self-incrimination that limits what police can do in interrogations. The Due Process Clause of the Fifth Amendment, that no person deprived of life, liberty, or property without due process, limits what the police can do, such as I'll talk about with regard to eyewitness identifications. Notwithstanding this, from 1791, when these provisions were adopted, to the late 19th century, there wasn't one Supreme Court case about them. Some of it is they didn't yet have application to state and local governments. Some of it was how little policing was done at the federal level. But what that means, in just the most basic terms, is that the Supreme Court wasn't for a century enforcing the constitutional limits on policing. And in fact, in the first half of the 20th century, almost all of the Supreme Court cases, except in the most extreme circumstances, ruled in favor of the police. An easy example. In 1928, in a case called Olmstead versus United States, the Supreme Court first considered whether the police needed to get a warrant when they engaged in wiretapping. It was a case arising out of prohibition. And the Supreme Court, an opinion by Chief Justice William Howard Taft, said, so long as the police don't trespass onto someone's property, they don't need to get a warrant in order to engage in wiretapping. So the police could eavesdrop someone's conversation, so long as they put the tap on the phone on wires outside the residence. Justice Louis Brandeis wrote a very eloquent and famous dissent. We talk about the importance of the right to privacy and the right to be let alone. It wasn't until the Warren Court, which began in 1953, that the Supreme Court began to impose significant limits on the police. The Warren Court did many things. In 1961, it said, if state and local police engage in illegal searches and arrests, the evidence gained must be excluded. In 1963, in Gideon versus Wainwright, the Supreme Court said, if a person is tried for a crime in state court where there's a possible prison sentence, the person has to be provided a lawyer if he or she can't afford one. In 1966, in Miranda versus Arizona, the Supreme Court said that when police question people in custody, it's inherently coercive, and the police have to give warnings. Warnings we're all familiar with from watching police shows. But the Warren Court ended in 1969, and it was followed by the Berger Court, and then the Rehnquist Court, and the current Roberts Court. And the story that I tell in the book is how each succeeding court became more conservative, and to the point of the book, more pro-law enforcement and less willing to impose limits on the police. Well, that's what I want to talk about this afternoon. And I thought that the easiest way to do it, we divide my remarks into three parts. First, what the Supreme Court has said about the content of the rights protected by the Constitution. Second, what the Supreme Court has said about the remedies when there's violation of those rights. And then third, I want to talk about the solutions that I propose going forward. And I think in this way, I can give you the thesis of the book, but also present to you examples so it's clear what I'm talking about. So the first part of our remarks is the rights that we possess under the Constitution when it comes to policing and what the Supreme Court has said about them. I focus especially on three rights in the book, and I've already alluded to them. The Fourth Amendment right to be free from unreasonable searches and arrests, the Fifth Amendment protection against self-incrimination, and the Fifth Amendment due process protection, especially with regard to eyewitness identification. Let me focus, just for sake of time, on a couple of them here. Let me talk about the Fourth Amendment. The reality is that notwithstanding the Fourth Amendment, the Supreme Court's decisions have made it such that the police can stop virtually any person at any time and search them. This is a power that disproportionately is used against people of color. And what I want to try to show you from the cases is that what I just said isn't hyperbole, that the police really can stop anybody anytime they want. The story of this ironically begins during the war in court in 1968 in Terry versus Ohio. As much as any single Supreme Court case in history, it's Terry versus Ohio that legitimated and upheld racialized policing. Let me tell you the facts of Terry versus Ohio. A police officer in Cleveland, Ohio, was walking his beat. He saw two men on a street seeming to pace back and forth. Now, they weren't doing anything illegal. They were walking on a public sidewalk. I don't think it's coincidence that the police officer was white and the two men he was observing were black. The officer said he thought that the two men were, quote, casing the joint. So the officers decided to take the two men, seize them, pushing them into a store, having them with their hands down and the legs spread, and then frisk them. He did this and he found a gun on the two men, and they were arrested for illegal possession of a gun. Their lawyers argued that it was an illegal stop and an illegal search, and that therefore the guns couldn't come in as evidence. Remember, the Fourth Amendment to the Constitution requires that there be probable cause for any police stop or any police search. No one, not even the state of Ohio, claimed that there was probable cause here that they had committed a crime. All they were doing was walking on a public sidewalk. But the Supreme Court 8-1 ruled in favor of the police officers. This was the moment in time when the Supreme Court was most liberal in all of its history. The majority opinion was written by Chief Justice Earl Warren. The justices in the majority included liberal lion William Brennan, Justice Thurgood Marshall, the greatest civil rights lawyer in history. Only William O. Douglas dissented. Chief Justice Earl Warren, writing for the court, said that the police can stop and frisk somebody without needing to have probable cause. They only need to have reasonable suspicion that the person might commit a crime. Now, probable cause is the standard in the Constitution. Those words are in the Fourth Amendment. Reasonable suspicion doesn't appear anywhere in the Constitution. Probable cause is language that comes from English law. There have been almost 200 years of American law developing a definition of it and articulate what it means. The court didn't give us a definition of reasonable suspicion, other than it requires much less than probable cause. My students are always frustrated when I teach criminal procedure that the court doesn't provide a definition of reasonable suspicion. As recently as 2 years ago, the court said it wasn't going to provide a definition. The court said it's more than a hunch and less than probable cause. Why did the Warren Court, at its most liberal point in history, hand down a decision that so empowered the police to be able to stop and search anyone? I think you've got to put it in the context of the time, 1968. The Warren Court decisions earlier that decade that limited what the police could do were widely criticized. They were seen as handcuffing the police. Richard Nixon was running for president in 1968, largely against the liberalism of the Warren Court. He said that if he were elected president, he would appoint justices who were strict constructionists committed to law and order. If you remember, in the mid-1960s, there was urban violence in so many cities across the country. Between the time that the Supreme Court heard oral arguments in Terry versus Ohio and when it decided the case, Dr. Martin Luther King was assassinated on April 4th, 1968. Followed that were riots across the country. Crime rates were very high in 1968. And I think the only way to understand this Supreme Court decision is a product of the times. It was predictable that this would make it easier for police to engage in racial profiling. The NAACP Legal Defense Fund wrote a brief to the Supreme Court, urging them not to abandon probable cause as a standard, because it would make it easier for the police to justify stopping people on the basis of race. Justice William O. Douglas, in his solo dissent, argued that what the Supreme Court was going to do was legitimate racialized policing. And of course, the studies have proven this is exactly what happened. There was a lawsuit brought in the federal district court in New York, Floyd versus City of New York, where they gathered the statistics about who had been stopped in New York and frisked over a 10-year period. The statistics were startling in terms of how much more frequently Blacks and Latinx individuals were stopped compared to white individuals, even though when white individuals were stopped, they were far more likely to be found to have weapons or contraband. As a result of the settlement in that case, stop and frisk was eliminated in New York as a police tactic, and there was no increase in crime in the immediate years following that decision. But Terry versus Ohio is crucial, remains the law to this day. The police can stop anybody, frisk anybody without needing probable cause, just if there's reasonable suspicion. But then the Supreme Court followed this up, decisions that made it even easier for the police to stop and frisk almost anyone at any time they want. Let me tell you of another Supreme Court case that I talk about in the book, Wren versus United States from 1996. Some undercover police officers were driving around in Washington, D.C. They said they were in a, quote, high crime area. That's, of course, a euphemism for a community with a large number of residents who are individuals of color. The police officers said they saw a car stop at a stop sign an unusually long amount of time, 20 to 25 seconds. I have the world's worst sense of direction. When there used to be maps, I used to be stopped often at a stop sign that long, trying to turn the map to try to figure out where I was going. Now I'll often be stopped that long to try to read my GPS. The only basis for suspicion of this car was it was stopped 20, 25 seconds at a stop sign. In Washington, D.C., undercover police officers are not supposed to be enforcing traffic laws. The rules prohibit it. But these undercover officers decided to follow this car until the driver committed a traffic infraction. They followed the car for a short time, and the driver changed lanes without a turn signal. The police pulled over the car, for the infraction of changing lanes without a turn signal, ordered the driver and the passenger out of the car, and then did a search of the car. No one disputes that this was a pretextual stop. The officers weren't stopping the car because they cared about changing lanes without a turn signal. They were stopping the car because they wanted to be able to search for drugs. They did that. They searched the driver and passenger area. They found illegal drugs. The driver and the passenger said there was no probable cause here. And this stop, this search was just a pretext. The Supreme Court ruled in favor of the police. Justice Scalia wrote the opinion for the court. He said, so long as the police have reasonable suspicion that there's a traffic infraction, the police can stop the driver. The police can order the driver and passenger out and search the area of the car that the driver and passenger are occupying. The court said it doesn't matter if it's a pretext. Justice Scalia said it doesn't matter if it's racially motivated. So long as there's reasonable suspicion, let alone probable cause, police are allowed to pull over a car. In doing research for this book, I talked to a police officer, and he said to me, if I follow any car for about 15 minutes, I'm sure to see some traffic infraction. Going a mile over the speed limit, changing lanes without a signal, turning without a signal, or if nothing else, the officer can say, the car didn't stop long enough at the stop sign. What's long enough is so subjective. It's easy for the officer to say, you didn't stop long enough at the stop sign. That's why I'm pulling you over. And once the officer pulls the car over, as I said, under Supreme Court precedent, the officer can order the driver, passengers out of the car, can frisk them and search the interior of the car. That's why it wasn't hyperbole when I said the Supreme Court has made it possible for the police to stop, search almost anybody at any time. But let me give you another example of this. Another Supreme Court case, Illinois versus Wardlow from 2000. William Wardlow was walking down the sidewalk in Chicago. He wasn't doing anything wrong. He was literally walking down the sidewalk. He saw 4 cars coming at him that he recognized to be police cars. In seeing the police cars driving down the street coming towards him, he decided to walk in the other direction. The police cars weren't after William Wardlaw. They were just driving someplace else. But one of the police cars, one of the officers, saw Wardlaw walk in the opposite direction. And that caused the officer to be suspicious of Wardlaw. He said, why is Wardlaw walking the other way? Maybe he has something to hide. Just based on this, and I've left out no facts, the police car pulls over, orders Wardlaw to stop, frisks him, and finds that in a bag he's holding, there's a gun. Wardlaw was a felon, ex-felon, and he wasn't allowed to possess the gun. He gets prosecuted of being a felon in possession. His lawyer says the police had no probable cause or even reasonable suspicion. Wardlaw did nothing but change directions that he was walking. But the Supreme Court, an opinion by Chief Justice William Rehnquist, ruled in favor of the police and said, when the police saw Wardlaw change the direction he was walking, that was enough for reasonable suspicion. I can certainly understand why people, especially young Black men like Wardlaw, would want to walk the other direction when they see the police. Given the statistics that I quoted at the beginning, there's so many others like them, but greater police violence against young men of color. Didn't it make sense that Wardlaw, on seeing police cars coming, would just want to walk away from them? But walking away from them was enough for reasonable suspicion, enough for the search. Now, I go through many other examples in the book of how the Supreme Court has empowered the police to stop and search virtually anyone at any time. But you get the idea. Let me give you the most recent example of one of the most recent examples of this. It's a case from 2016, Utah versus Streef. Police got an anonymous tip that there was drug dealing going on at a house in Salt Lake City. So an officer, Douglas Frackle, decided to watch the house. He saw a man, Edward Streef, go into the house and quickly come out. Now, there was no probable cause or even reasonable suspicion that Streef had done anything illegal. He went into a house and he came out of the house. The officer followed Streef to a nearby strip mall, stopped Streef as he was going into a convenience store, made Streef identify himself, and Streef produced his driver's license. And the officer detained Streef while the officer did a warrant check to see if there were any outstanding warrants for Edward Streef. There was an old outstanding warrant for a traffic violation. The officer arrested Streef based on that old warrant for traffic violation, searched Streef incident at the arrest, and found drugs. And the question is, did the drugs have to be excluded from coming in as evidence? The Utah Supreme Court, not one of the more liberal Supreme Courts in the United States, unanimously ruled in favor of Edward Streef. But the Supreme Court reversed an opinion by Justice Thomas. The court admitted that there was no probable cause or reasonable suspicion for the stop of Edward Streef. But Justice Thomas said, once it was found there was an outstanding warrant, then the police were justified in searching him, and then they could find the drugs. Not long after this case came down, I got a call from an inspector general of a major police force in the United States. And he said they had a huge increase in their police officers engaged in illegal stops. Why? The officers were educated about this case, and they learned they can illegally stop somebody, check to see if there's an outstanding warrant. If there's no warrant, they say, you can go. And they're not going to get sued for the illegal stop. If there is a warrant, they can then search the person. If they find nothing, they can let the person go. And if they find anything, drugs, weapons, contraband, it's then admissible as evidence. The Supreme Court has very much again opened the door to the police and to racialized policing. Well, let me give you another very different example that I also focus on the book. And this concerns eyewitness identifications. Study after study has shown that many innocent people have been convicted on the basis of inaccurate eyewitness identifications. Thanks to the work of the Innocence Projects, many people who were convicted were later exonerated, especially when DNA was found that shows that they weren't the one who committed the crime. There's efforts when people are wrongly convicted to see what led to their wrongful conviction. Time and again, it's found that they were convicted on the basis of a false eyewitness identification. Some studies have found that well over half of the innocent people who we know to have been convicted were wrongly convicted because of an eyewitness identification. Social psychologists tell us why eyewitness identifications are often inaccurate. People, a victim of a crime, a witness, sees the suspect in a very fleeting way. Often the victim, the witness, is under great stress. Often conditions for observation, like lighting, are limited. Social psychologists and study after study also tell us that cross-racial identifications are particularly apt to be flawed. That when people are identifying those of other races, they're much more likely to be mistaken. In 1968, the Warren Court, for the first time, put a limit on police use of eyewitness identifications. In a case called United States versus Wade, the Supreme Court said a lot of innocent people have been convicted because of faulty eyewitness identifications. The Supreme Court said, when somebody's been indicted and the police do a lineup, the criminal suspect has a right to have an attorney present. The court said the attorney will decrease the likelihood the police will engage in a suggestive eyewitness identification. The lawyer's there as a witness. But then at the end of the war in court, the Supreme Court continually limited the rights of criminal suspects when there's eyewitness identifications. So for example, the Supreme Court said, if the lineup is held before the indictment, there's no right to a lawyer. The court has said, if it's a photo identification where the police shows someone a series of pictures and say, can you spot the culprit? No need for a lawyer. And there's lots of recorded instances where the police will show a victim or a witness 6 photos, and the officer will tap on the one that they think is the suspect or give other nonverbal cues as to who they expect to be picked. And then the Supreme Court went even further and said that even if the police identification procedure is very suggestive, it's still admissible in court if the judge believes it's reliable. And so there's instances where police officers will take one suspect to a victim, say in his or her hospital room, and say, is this the one? And of course, when there's that kind of show up, it's so easy for the victim to say, yes, that's the one, because the victim is seeing one person and generally somebody who fits the description. We know in many instances that such procedures have led to wrongful convictions. So the literature here is overwhelming about people being wrongly convicted because of faulty eyewitness identification. William Rehnquist became Chief Justice in 1986. Do you know how many Supreme Court cases there have been about police identification procedures since 1986? 1. It was a decade ago, and it ruled in favor of the police. What this then means is that since 1986, the Supreme Court has essentially completely ignored the problem of eyewitness identification. Only one case in all that time, and it ruled in favor of the police. And the lower courts and the police have gotten this message. If I could change one thing about the law in this area, it would impose far greater limits on how the police conduct eyewitness identifications and much greater restrictions on what can be introduced in court. So that's the first part of my remarks, how the Supreme Court has limited the scope of the constitutional rights that we possess when it comes to policing. In the second part of my remarks, I want to talk about remedies. Rights are meaningless unless there's remedies. Unless there's effective remedies, the most eloquent and elaborate statement of rights becomes worthless. This isn't a new insight. This is what Marbury versus Madison said in 1803. In the first part of my remarks, I just told you how the Supreme Court has limited the scope of constitutional rights. In the second part of my remarks, what I tell you is that even where there is a right, the Supreme Court has so greatly limited the remedies that exist for the violation of rights. Well, what are the remedies that exist when police violate rights? One possibility is civil suits. Sue the police department, sue the police officer, sue for an injunction, sue for money damages. Well, the Supreme Court has made such suits enormously difficult. I've already told you in City of Los Angeles versus Lyons, the Supreme Court made it very difficult to sue police departments for injunctive relief. A person can be a plaintiff and sue a police department for an injunction only if the person can show that he or she is personally likely to be injured again in the future. You say, well, what about suing for money damages? Who might you sue for money damages if you're a victim of police abuse? One possibility is to sue the government entity that employs the police officer. Most policing is done at the local level, so sue the city of Berkeley for what the Berkeley police do, or the city of Oakland for what the Oakland police do, or Alameda County for what the Alameda County Sheriff does. but the Supreme Court has made that very difficult. In 1978, in Monell versus Department of Social Services, the Supreme Court said that a local government can be held liable for constitutional violations only if its own policy causes the constitutional violation. The city can't be held liable just because one of its officers, a police officer, violates the Constitution. This is different from the law in most other areas. If an Amazon truck driver gets in an accident, Amazon is liable. If a UPS driver gets in an accident, UPS is liable. But if a police officer violates somebody's rights, the city is liable only if its own policy or custom causes the violation. And the Supreme Court has made it very difficult to prove municipal policy. So, for example, when George Floyd's heirs sued the city of Minneapolis with regard to his death, had it gone to trial, they would have been able to win only if they could prove that a Minneapolis policy with regard to choking authorized what George Floyd did. It'd be very hard to show. They would have to show the Minneapolis policy caused the death of George Floyd. Now, the city of Minneapolis, I think wisely and understandably, chose to settle the case rather than to litigate. But it was very hard for the victim, George Floyd's estate, to bring a successful suit. Well, you can't sue the city for an injunction. Very difficult to sue the city for money damages. What about suing the police officers, the ones who violate constitutional rights? The Supreme Court has made this very difficult as well. A little bit of background. A federal statute, 42 United States Code, Section 1983, says that whenever a government officer violates the Constitution or laws of the United States, the government officer can be sued for money damages. It's specifically about state and local government officials. And if a police officer violates somebody's constitutional rights, the police officer can be sued for money damages. There's the statute, Section 1983. This law was adopted in 1871 as the Civil Rights Act. But in the last 40 years or so, the Supreme Court has invented defenses to the law. And I choose the word invented quite purposely because the defenses aren't mentioned in the statute. They're created by the Supreme Court. The Supreme Court has said that any government officer sued for money damages has either absolute immunity or qualified immunity as a defense. Some government officials have absolute immunity. No matter how egregious their constitutional violation, they can't be sued for money damages. Judges for the judicial acts. There was a Supreme Court case, Morales versus Waco, that involved a witness who didn't show up when he was subpoenaed to court. The judge said to the bailiff, "Go and find him up and rough him up and show him he can't ignore a subpoena from my court." The bailiff went and really beat the guy up. And the man sued the judge and said, the judge shouldn't be able to order I be beaten up by the bailiff. And the Supreme Court ruled judges have absolute immunity for their judicial acts and can't be liable. Prosecutors for their prosecutorial acts have absolute immunity. There was one case, Imbler versus Pacman in 1976, that involved a prosecutor who knowingly used perjured testimony that led to the conviction of an innocent person, spent 9 years in prison for a crime he didn't commit. When the real culprit was found, he sued the prosecutor. And the Supreme Court said, you can't sue a prosecutor for money damages for what the prosecutor does in the role of prosecutor. To take it back to the topic today, the Supreme Court has said police officers cannot be sued for money damages for testimony they give as a witness in court, even if the officer commits perjury, lies under oath, even if it leads to the imprisonment or death of an innocent person, the police officer can't be sued for money damages. That's absolute immunity. And again, it's invented. It's not anywhere in the statute. The Supreme Court created it. But all government officials who don't have absolute immunity have qualified immunity. I've been teaching about qualified immunity since the Supreme Court created the doctrine in the early 1980s. And it's interesting now to see part of the popular vocabulary, people talking about qualified immunity. Qualified immunity means that a government officer can be liable only if he or she violates clearly established law that every reasonable officer should know. And it has to be a right established beyond debate. The Supreme Court has said frequently that qualified immunity protects all but the plainly incompetent officer. In case after case involving excessive police force, the Supreme Court has ruled in favor of the police officers based on qualified immunity. Let me give you an example from October of 2021, a case called City of Tahlequah, Oklahoma versus Bond. What's involved here is a woman called the police that she was being harassed by her ex-husband. The police came there, and the ex-husband was in a garage tool shed area, and the police officers wanted to talk to him. The man reached behind him and picked up a hammer. Now, the man was far enough from the police that even if he threw the hammer, it wasn't going to cause any harm to the police. But the officer said to him, "Put down the hammer." When the man didn't do that immediately, the officer shot and killed the man who was holding the hammer. The deceased estate sued the police and said, "This is excessive force. This was unreasonable." And the United States Court of Appeals for the 10th Circuit ruled in favor of the estate, saying that what the police did here in shooting and killing this man was excessive force, and the officers weren't protected by qualified immunity. But the Supreme Court reversed the lower court, and the Supreme Court said that the officers were protected by qualified immunity and could not be held liable. Qualified immunity has become an enormous obstacle to suing police when they violate constitutional rights. A group of reporters at Reuters a couple of years ago did a study of qualified immunity in the lower federal courts. They won a Pulitzer Prize for the study, and it documented how often police win in excessive force cases because of qualified immunity. So when you think about remedy, bringing a lawsuit against government, against the government officials, is enormously difficult. Well, there's one other remedy for constitutional violations: the exclusionary rule. The exclusionary rule says if police gain evidence in violation of the Constitution, the evidence is inadmissible. It has to be excluded. The exclusionary rule was first created by the Supreme Court in 1914, when federal law enforcement violated the Fourth Amendment. As I alluded to, it was applied to state and local governments in 1961. And yet, the Supreme Court has dramatically narrowed when the exclusionary rule applies. It wouldn't surprise me to see it completely eliminated in the future. A key case here was Herring versus the United States in 2009. A police officer saw someone driving, and the officer had previous interactions with the person, and the officer decided to see if there are any outstanding warrants on the man. And the officer phones it in, and it turns out the computer database showed there's an outstanding warrant. The officer pulls the man over, does a search, and finds that he's in illegal possession of a gun. Well, it turns out there was no outstanding warrant. It was an error in the database. An old warrant that had since been resolved still appeared there. So the police pulled this man over without probable cause or even reasonable suspicion. Should the evidence be excluded because the police violated the Fourth Amendment? The Supreme Court 5-4 said the evidence should not be excluded. Chief Justice Roberts wrote for the court. He said, when police violate the Fourth Amendment in good faith or negligently, the exclusionary rule doesn't apply. It said only if the police recklessly or intentionally violate the Fourth Amendment does the exclusionary rule apply. Think of an instance where a criminal defendant is charged with a serious crime. Most state judges are elected. They don't want to appear soft on crime. They don't want a dangerous person to go free. So they have every incentive to say the police violated the Fourth Amendment in good faith or just negligently and not exclude the evidence. Attack in the area of eyewitness identification. So long as the judge says the testimony is reliable, no matter how suggestive the identification procedure, the identification can go on in court. It is admissible. And I think the court may go even further in eliminating the exclusionary rule. In 2006, in Hudson versus Michigan, 4 justices, Scalia, Roberts, Thomas, and Alito, called for the complete elimination of the exclusionary rule. So no matter how much the police violate the Fourth Amendment, the evidence is admissible. Justice Kennedy was the 5th vote for the result in that case. And he said, quote, "The continued operation of the exclusionary rule is not in doubt." But Kennedy's no longer on the court. There are 3 very conservative justices who were appointed by President Trump. My sense is there's now a majority to eliminate the exclusionary rule. So even if police violate somebody's rights, what remedy will there be if there can't be civil suits and if there's no exclusionary rule? That leads me to the third and final part of my remarks this afternoon. What are the solutions? I was determined when I wrote this book to not just identify the problem, but to also point to solutions. I don't think the solution is going to come from the United States Supreme Court in the foreseeable future. None of the 6 conservative justices, Roberts, Thomas, Alito, Gorsuch, Kavanaugh, Barrett, have ever indicated that they see any problem with policing in the United States. None has even hinted they see a problem with regard to racialized policing in the United States. And we're likely to have a very conservative Supreme Court for a long time to come. Amy Coney Barrett was 48 years old when she was sworn in as a justice on October 26, 2020. If she remains on the court until she's 87, the age which Justice Ginsburg died, Barrett will be a justice in the year 2059. I've long thought that the best predictor of a long lifespan is being confirmed for a seat on the Supreme Court. When Barrett was sworn in, Neil Gorsuch was 53, Brett Kavanaugh 55, John Roberts 65, Samuel Alito 70, and Clarence Thomas 72. John Paul Stevens didn't retire until he was 90. So it's easy to imagine 5 or 6 of these justices being together another decade or 2. So if we want reforms in policing, we have to look elsewhere. But there are other places to look. One possibility is looking to the political process, to Congress, to state legislatures, to city councils, to local police commissions. Historically, they have not been very effective in putting limits on the police. The reality is that elected officials want to seem tough on crime. They don't want to give their opponent some easy issue for the next election. But I was very hopeful after the death of George Floyd that that might inspire political action at all these levels of government. The protests after the death of George Floyd were really unprecedented in American history. They occurred in all 50 states, even in the midst of a pandemic. They involved a huge number of people. And it really seemed there was a focus on reforming the police. There was a bill introduced into Congress, the George Floyd Police Reform Act, that would have done many things. It would outlaw the police use of the chokehold. It would greatly limit the ability of the police to enter a residence without knocking and announcing first. So it's very dangerous to the officers and those there. And that led to the death of Breonna Taylor. It would require that the police record the race of everyone they stop, which by itself has been shown to decrease the likelihood of racial profiling. And these are just a few of the things it would have done. It also would have changed the definition of qualified immunity, since qualified immunity comes from the Supreme Court's interpretation of a statute, not from the Constitution. Congress could alter it. The House of Representatives passed that bill in the summer of 2020. It languished in the Senate. In this session of Congress, the House of Representatives again passed the bill, and once more, there seems no likelihood that it's going to pass the Senate. There's the possibility of state legislatures acting, and we've seen that in some states. California adopted a law essentially prohibiting police from using the chokehold. This past fall, the legislature adopted a number of laws that Gavin Newsom signed that are important. As examples in California, now an officer has a legal duty to stop misconduct by another officer. Now, if an officer is decertified based on misconduct, another department can't hire that person. Also, with regard to police force, under the US Constitution, the question is, was the use of deadly force reasonable? Under a new California, relatively new California statute, deadly force has to be necessary under the circumstances. Local governments in many areas have adopted some police reforms. A number of cities have prohibited their police from using the chokehold. But I have to tell you that when I finished this manuscript in October of 2020, I was much more hopeful that it would lead to major reforms of policing. There have been some reforms, but not nearly what I had hoped for a year and a half ago. There's another source of change, and that's state courts interpreting state constitutions. Every state has its own constitution, and every state under its state constitution can provide more protection of rights than the US Constitution. I'll give an easy example. The United States Supreme Court has said there's no First Amendment right to use privately owned shopping centers for speech purposes. But the California Supreme Court has said, under the California Constitution, there is a right to use private shopping centers for speech purposes. Or another example, the Supreme Court has said police searching of a person's garbage doesn't require a warrant or probable cause under the Fourth Amendment. Many state courts have said, under their state constitutions, searching of a person's garbage does require a warrant and probable cause. Or another example of this, I mentioned to you, the United States Supreme Court has said that a pretextual stop doesn't violate the Fourth Amendment. Some state Supreme Courts have said that a pretextual stop does violate their state constitution. The Supreme Court has said that suggestive eyewitness identifications are admissible if they're reliable. Many states have said under their state constitutions that a suggestive eyewitness identification is not admissible at all. In 1977, then Justice William Brennan wrote an article in the Harvard Law Review urging more use of state constitutions to protect rights. It's even more urgent today. One more possible remedy. There's a federal statute, 42 United States Code, section 14141, that allows the Justice Department to sue police departments if there's a pattern and practice of civil rights violations. This has been a very important tool in the past for reforming police. The Justice Department used this to sue police departments in cities like Baltimore, Cincinnati, Seattle, Los Angeles. I'm most familiar with Los Angeles. I lived in Los Angeles at the time this was going on. I was a professor at USC. In the year 2000, after the Rampart scandal, I was asked to chair a major study of the Los Angeles Police Department, made many recommendations for reform. The Department of Justice told the city that it had found a pattern and practice of rights violations, and the city decided to settle with the Justice Department. They entered into a consent decree, an agreement that's over 100 pages long that include many of the reforms that I proposed. A study was done by the Kennedy School of Government at Harvard University that found that the consent decree in Los Angeles between the Justice Department and the city dramatically decreased instances of violence and excessive force by the police. Unfortunately, the Trump Justice Department announced it wasn't going to use the statute. Attorney General Jefferson Sessions said that they would not enforce existing consent decrees or seek new ones. And then Attorney General William Barr said the same thing. The Biden Attorney General, Merrick Garland, has said they will use this authority, but we'll see how it's used and whether it's used, what circumstances it's used. But there are ways of reforming police departments without needing to rely on the Supreme Court. As I said, when I finished this manuscript and turned it to the publisher, I was very hopeful that what had occurred in the United States after the death of George Floyd was going to be the impetus for meaningful police reform. We've seen some, but not enough. Now I worry that it's going to take the death of the next George Floyd, Eric Garner, or Walter Scott, or Laquan McDonald to be the impetus for the reform that's so necessary. Said I would talk for an hour. We've come to 4 o'clock. I'm glad to take questions about anything I talked about or anything with regard to the Supreme Court.
Okay, great. Let's do this, if you're willing. Let's take about 3 minutes for people to pop questions into the chat, and then we'll go ahead so we have as much time between now and 4:30 to have Dean Chemerinsky talk about anything. We have a series of questions in the chat about police.
Let's
I'll try
start.
to pick. You want to take them and run with them?
Yeah, let's just
Okay.
start. Do you want me to read them or do you want to read them?
Whichever you prefer.
Whatever
Erwin.
you prefer. I'm glad to read them out loud. I have not seen
Sure.
them obviously previously, but let me see if I
Okay.
can
Let-
scroll up to the beginning.
Okay,
I'll
let me.
read them, and some have come to me privately.
Okay, let me
What's
also
your-
point out that you've said you'll answer questions on anything the court is up to right now. So if
Yes.
people have questions about religion, gun control, affirmative action, abortion, please feel free to pop those questions in. With respect to
Mhm.
police, Erwin, if I could ask you one just to begin with. It's hard for me, and I'm hoping you can help me understand the thought processes of the conservative justices on this topic, as well as many others. It seems as though, I wonder if it's just intellectual dishonesty, mendacity and prevarication, hypocrites. How can they possibly not see the things you're talking about? Are we just dealing with, cold, hard racism on the court? Forgive me for asking you, a question that puts you in a tough spot, but
It doesn't-
I just can't
Um,
fathom it.
we all look at the world from the perspective that we start with. And if you start from the perspective that there's a great deal of implicit bias and sometimes overt racism in policing, that leads you to one set of conclusions. If you start from a different set of assumptions, that the police don't have implicit bias in racism and that you make certain assumptions about who's likely to commit crime, you come to a different set of conclusions. Or I'll put it to you another way. At least since the 1960s, there's been a large conservative versus liberal divide on how to approach policing in the United States. Conservatives have very much wanted to empower the police, and liberals have very much wanted to limit the police. And I think it just, like so many issues, comes back to where do you start?
And do you think that they can see the Wild West coming once they let everybody carry a gun? Obviously, the police are going to be even more frightened and ready to pull their guns. Do you think they appreciate just how wild it's going to get out there? Or am I wrong to think it'll get wild?
Well, it will. I think the Supreme Court in the case that was argued on November 3rd, New York Rifle and Pistol Association versus Bruin, is likely to say that people have a right to have weapons when they're out in public, including concealed weapons. I think that studies show the more people have weapons, the more they're used and the more violence there is. But I imagine they may tell themselves either this is the Second Amendment right, or maybe the more guns there are, the less violence there be. Some believe that the answer to gun violence in schools is to arm teachers.
Yes.
I think that is a terrible idea. But that's what we've heard from some people.
Okay.
Should I
We're
start
off
some
and
of the
away.
questions?
Absolutely. You can
I'm
start
reading
right
them in
at
the
top.
order in which they came.
Mhm.
And I'll get to as many as I possibly can before 4:30. What's your guess as to the result of the Harvard UNC affirmative action cases? I think that the Supreme Court is going to dramatically change the law with regard to affirmative action. In 1978, Regents, the University of California versus Bakke, 2003, Grutter versus Bollinger, in 2016, Fisher versus Texas Austin, the Supreme Court said that college universities have a compelling interest in having a diverse student body and may use race as one factor among many in admissions decisions to benefit minorities. I think the Supreme Court is going to overrule those decisions and hold that colleges and universities cannot use race as a factor in admissions decisions. This won't matter here in California. Proposition 209 already prohibits race from being used as a factor in admissions, but it will make a huge difference in admissions in many parts of the country. And I'm going to have an op-ed online in the LA Times tomorrow and then in the paper in a day or so on this, where I develop the point more fully. If people are presumed guilty, if people of color are presumed guilty, is the corollary true that white suspects are presumed innocent by police? We all have implicit biases. And there's no doubt that the police have implicit biases. And I think their biases affect how they look at people of color and how they look at white people. I'm not discounting that there's some police officers who are openly racist. There's too many officers who are members of white supremacist organizations. It's been documented. But I think the reality isn't about racism. I think it's about the implicit biases, but people of color and white people. Since you wrote your book, has anything changed your mind about actions that reasonable citizens can take to make the Supreme Court less activist or encourage them to respect settled law? As I said in my first words today, this is going to be a momentous year in the Supreme Court. I think the court's about to overrule Roe versus Wade. I said to Bill, I think the court's about to dramatically expand gun rights. And it won't be until next year that I think the court's going to eliminate affirmative action. I don't think there's anything that's going to change that as long as we have these justices. Since I wrote the book, remember, I really wrote the book in the summer of 2020, and it was only on September 18th, 2020, that Justice Ginsburg died, and October 26th, Justice Barrett was confirmed. And I think that makes it even harder to get a majority on the Supreme Court to impose limits on the police. Did Lyons assert a damage claim with respect to the chokehold? The Supreme Court said Lyons could sue for damages, but he couldn't sue for an injunction unless he likely to be choked again in the future. And the court said Lyons' damage claim could go forward. It was just about the suit for an injunction that was being limited. So if people want to sue the police for damages, they can sue. And hopefully the damage judgment might keep the city from doing in the future or cause them to change their policy for the future. Would you comment on the increasingly conservative Supreme Court since the Warren Court led an increasingly socially liberal population? It seems the Supreme Court is increasingly in touch with the people of this country. I always think of the American people as somewhat just to the left of center or right of center overall. And we can talk about, does the election of Barack Obama show an American people left of center, or does Donald Trump, though he lost the popular vote, it was only by 3 million in 2016 and 7 million in 2020, show a population maybe a little bit right of center. But we have a Supreme Court with 5 justices very far right of center. How did we get here? From 1960 to 2020, we had 32 years with a Republican president and 28 years with a Democratic president. Almost even. In 2024, it'll be exactly even, 32 and 32. But during that time, from 1960 to 2020, Republican presidents picked 15 Supreme Court justices and Democrats picked 8 Supreme Court justices. Or I'll put this in an even more startling way. Donald Trump, in 4 years, picked 3 Supreme Court justices: Gorsuch, Kavanaugh, and Barrett. If you look at the prior 3 Democratic presidents, Jimmy Carter, Bill Clinton, and Barack Obama, they served a total of 20 years in the White House, and they, in those 20 years, picked only 4 Supreme Court justices. And Republican presidents, especially in recent years, have wanted to pick very conservative individuals to please the core of the Republican base. That's what leads to the court that we have today. Now, an opinion poll that was done by Gallup in the fall showed that the Supreme Court had the lowest approval ratings of any time in history. It had a 43% approval, 40% approval rating and a 53% disapproval rating. Perhaps that reflects a court that's out of touch. 2/3 of the American people say that Roe versus Wade shouldn't be overruled. but that's what the court's about to do. Next question, there's lots of them. In the Lyons case, wasn't there an argument that police represented the state, had parents' patriotic duty to protect the public, also argued chilling on police performing their duties leading to protecting the police? Well, of course, the police have the duty to protect the public, and the police should be able to protect themselves. The question was, did the officer need to choke Adolph Lyons into unconscious? There's many ways in which the police can control suspects, but the chokehold, for reasons I discuss in the book, is particularly dangerous. It's what led to the death of George Floyd, of Eric Garner, and so many others. And I think that what the state of California has now said is that when police need to control somebody, they've got to do it in a means less likely to be lethal. Let me scroll down. Is not the Supreme Court supposed to operate independently of what is in the news? What changes in the Supreme Court need to happen to overturn reasonable suspicion? The Supreme Court, of course, is supposed to enforce the Constitution, but the Constitution is written in very broad language, and how it's interpreted depends on who's on the bench. The Supreme Court always has to balance competing interests. How they do that is a function of who's on the bench. What can be done to overturn reasonable suspicion? Well, I think that the Supreme Court could overturn Terry versus Ohio, but failing that, I think state Supreme Courts can reject the reasonable suspicion standard for their state and local police departments, and it's a way of overcoming that standard. I recall a traffic stop my husband and I experienced in Berkeley for not stopping at a stop sign for long enough. We stopped for only 3 to 4 seconds. The cop tried to insist on a search of the car. We're 2 Asian adults with 2 toddlers in a car in a minivan. The only reason he let us go, as my husband was mentioning, is a staff attorney at the California Supreme Court. Here I can tell you the law. When the police stop somebody, even for a routine traffic infraction, not stopping long enough at the stop sign, they are allowed to order the driver and all passengers out of the car. They are allowed to do a search of the car, and anything they find is admissible. That was the point of Wren versus United States. So in response to the comment I read, the only thing that kept the police from ordering them out and doing the search was the goodwill of the police and respecting that this person was a lawyer for the California Supreme Court. That's part of what I'm describing about the ability of police to stop and search anyone at any time. One scary thing is that the Supreme Court cases seem to indicate the police being honest about the factual reasons for the stops. It seems that in reality, police manufacture a pretext for reasonable suspicion. I discussed this at some length in the book. There's even a label for it, a word. It's called testifying. It's how police, after the fact, make up that they had reasonable suspicion. Another way it happens is police say, the person consented to my search. And it's the officer's word against the individual's word. The Mullen Commission in New York investigated the New York Police Department and found that testifying by police officers is widespread in these kinds of situations. Then Judge Alex Kaczynski on the Ninth Circuit wrote of the prevalence of testifying, and law professors have documented, and surveys of police officers have indicated that this is a real problem. And as I say, I didn't cover it in my lecture, but discuss it in the book. I'm scrolling down. What is the definition of reliable? This is in the context of eyewitness identification. The Supreme Court hasn't provided us one. So long as the trial judge believes that the eyewitness identification is sufficiently trustworthy, persuasive to be in, even if the police practice was suggestive. And so there's one case where a woman said that the assailant was a large African man of African descent. The police took one large black man into the victim's hospital and said, is he the one? And the woman said, yeah, he's the one. You can't get more suggestive than that. It was about half dozen police officers, all of whom were white, bringing one black man to the hospital room, and she said, yeah, that's the one. And the court said, well, that was very suggestive for the police to do, but her saying that it was him was reliable, so it was admissible. Not all eyewitness identifications are flawed. Why isn't good old-fashioned cross-examination to be used? I'm not saying that all eyewitness identifications are flawed. I am saying that studies have shown that many innocent people have been convicted because of flawed eyewitness identification. And many studies have shown that cross-examination doesn't expose the problems. And so once somebody has made an inaccurate eyewitness identification, they're very likely to stick to it in the future. And they're likely to be very certain in their eyewitness identification. Social psychologists like Elizabeth Loftus have documented that the certainty with which someone speaks of their eyewitness identification doesn't indicate reliability at all. The National Academy of Sciences, the Committee on Science, Technology, and Law has done a study about the prevalence of false eyewitness identifications and prescribed many things that should be done to try to decrease the likelihood of innocent people being convicted. What happens if you define disproportion on the basis of crime rate versus population? The Supreme Court won't accept that as a basis for determining what's disproportionate. There are many studies that are done that compare, say, the amount of crime committed by Blacks to the percentage of individuals percentage of Blacks stopped by police. And they find an enormous disparity. Blacks, Latinos are stopped by the police far in excess of the percentage of crimes they commit or the percentage in the population. Let me try to scroll down again. How does one prove flaws if there are no witnesses to the eyewitness identification procedure? This is a real problem, that the police can be very suggestive in the way they clear their throat or tap on a photo. And if there's no witness to the eyewitness identification, well, you can try cross-examination of the police and what they did. But that's why the case United States versus Wade in 1968 wanted a lawyer to be at the lineup. But then the Supreme Court said, only if it's a lineup after indictment, not for pre-indictment lineups. There was Kirby versus Illinois, not at photo identifications. That was Ash versus the United States. What is the legal logic for absolute immunity? I can tell you what the Supreme Court says. The Supreme Court says that the federal statute I mentioned, Section 1983, was, quote, written against a backdrop of common law immunities, in that Congress assumed that there would be absolute immunity. Also, the Supreme Court says we need to provide absolute immunity for some tasks because otherwise there'd be too many suits against the person and it would interfere with their performance of duties. So the Supreme Court has said a president can't be sued for money damages for anything done while in office. There's absolute immunity. Police officers can't be sued for money damages. There's absolute immunity for the testimony they give as witnesses. And the court's very concerned about a functional reason. There'd be too many suits interfering with the performance of duties by the officer. The witness is testifying as the events of the crime. Defense counsel can cross-examine the witness by the identification made from the factual situation of the scene of crime. And defense counsel do that. But studies of those who are wrongly convicted, studies by social psychology, show that there's a real limit on what cross-examination can expose. That often the person says, yes, the person that was brought to my hospital room was the culprit. And cross-examination can't dislodge that identification or do much to help. What effect, if any, will the George Floyd murder have on future Supreme Court decisions? I was hopeful after the spring of 2020 that the court might change the law of qualified immunity. There's been a great deal of criticism of it by conservatives as well as liberals. The conservative think tank, the Cato Institute, has been very critical of qualified immunity. Conservative judges, like Trump appointee to the federal courts, Don Willett, conservative law professors, like University of Chicago Professor William Bowd, have criticized qualified immunity. But it hasn't happened. The most recent qualified immunity case, including one I talked about, in October 2021, are just as pro-police as ever. and using qualified immunity to protect the officers from liability. Do not these immunities put individuals above the law? I think absolute immunity certainly does that. I can give you other examples where prosecutors did egregious things, where judges did egregious things, but because of absolute immunity couldn't be held liable. It sounds like you're arguing that the exclusionary rule should have allowed those detained to avoid arrest and retain their illegal weapons, if I'm misunderstanding. I think that if the police engage in an illegal search, the evidence should be excluded. So I believe that the stopping of, say, Terry or Wren or Wardlaw should have been found to violate the Fourth Amendment, and the evidence should have been excluded. A long time ago, in 1914, in United States versus Weeks, the Supreme Court said, when somebody is convicted on the basis of illegally obtained evidence, the courts are tainted, that no one should be able to be convicted when the police violate the law. And I wish the Supreme Court would have adhered to that. Might increased media focus on police malfeasance help to change public attitudes with the police? Yes. But I think that the public and media attention from June of 2020 has waned. The public's attention has shifted to other things. That's why I say I worry that it's going to take the next death of a George Floyd to focus the media and to focus the public. Would the elimination of judges being elected but installed by as an apolitical process help? Yes, in the sense that there have been many studies that show that elected judges are much more likely to be pro-prosecution and pro-police than appointed judges. But I also think it's unrealistic. Efforts to try to eliminate elected judges at the state level have not been successful. Justice Sandra O'Connor, after the bench, launched a major effort to eliminate election of judges in Nevada, and it failed. People don't want to vote themselves out of power. People who can choose judges don't want to give up that power. And no judge now wants to seem soft on crime. When Erwin Chemerinsky, following the recommendation of the probation department, imposed the sentence was seen as lenient, he was subject to a recall. But I can't think of any judge who's ever been subject to a recall for being too tough on crime. Does the current court's willingness to disregard precedent, is the concept of stare decisis all but dead? There's long articles in books written about precedent and stare decisis, and they always come to the same conclusion. Precedent should be followed except when it should be overruled. And of course, that's right. Precedent matters because it provides stability in the law. But we all believe there's times that precedent should be overruled. We all agreed that it was imperative that Brown versus Board of Education overruled Plessy versus Ferguson. I don't think that if Hillary Clinton won in 2016 and she'd appointed 3 justices, the liberals would have hesitated in overruling, say, Citizens United. But now I don't think the conservatives are going to pay any attention to precedent, and they're going to overrule Roe versus Wade. They're going to overrule the affirmative action cases. So I don't think precedent is a limit on the Supreme Court. And certainly I can point to other recent instances where the Roberts Court has overruled longstanding precedent, including in a case that I argued in the Supreme Court a few years ago, where the court overruled a 40-year-old precedent. Let's see. What will the Supreme Court decide in Dobbs versus Jackson regarding Mississippi's law permitting abortion after the 15th week of pregnancy? In Roe versus Wade in 1973, and yesterday was the 49th anniversary of Roe versus Wade, I think probably the last anniversary of Roe versus Wade, the Supreme Court held that states can't prohibit abortions prior to viability, the time at which the fetus can survive outside the womb. That's now put by medicine about the 23rd or 24th week of pregnancy. Mississippi law prohibits abortions after the 15th week of pregnancy. I think at the very least, there will be 6 justices to uphold the Mississippi law and say that states can prohibit abortions after the 15th week of pregnancy. I think Chief Justice Roberts in oral argument indicated that's what he'd like to do, say that states can prohibit abortion at least after the 15th week of pregnancy, and leave for future cases where the states can prohibit abortions even earlier, like the Texas law that prohibits abortions at the 6th week of pregnancy, or the Alabama law that prohibits abortions from the moment of conception. But from the oral argument, I think there are 5 justices who just want to overrule Roe versus Wade and allow states to prohibit all abortions. If I were a betting person, I'm not. I would bet that the Supreme Court in Dobbs is going to overrule Roe versus Wade. At the very least, I am sure they're going to uphold the Mississippi law. Are the statistics in other countries with respect to violence against guns ever taken into consideration by men's court? No. The United States has 5% of the world's population and 25% of the world's prisoners. The United States has a record of police violence far in excess of any other Western country. We have far more gun violence than in any other Western country. But no, I don't know of any Supreme Court case that's focused on that. Do you think Justice Breyer should step down now so Biden can appoint a replacement before Democrats possibly lose the Senate? Yes. In March 2014, I wrote an op-ed in the Los Angeles Times urging Justice Ginsburg to step down at the end of that term. I said, there's a Democratic president, Democratic majority in the Senate. Justice Ginsburg should step down this summer to let President Obama pick her replacement, and the Senate can confirm. So it's the only way she can have someone with her values and views take her place. I never imagined that Justice Ginsburg would pay any attention to what a law professor in Southern California was saying, but she responded with great anger. She gave interviews where she said, some, such as Erwin Chemerinsky, think I should retire, and I'm not going anywhere. No one can do my job as well as I can. She gambled that she'd be able to remain on the court to this Democratic president, and we all lost that gamble. Last June, I wrote an op-ed in the Washington Post urging Justice Breyer to step down at the end of last term in the summer of 2021. I signed on to an ad of law professors urging this. There's a Democratic Senate now, just barely. It's 50 Democrats and 50 Republicans with Kamala Harris as vice president breaking the tie. If President Biden were to pick someone now, the Democrats could confirm there's no chance of a filibuster for Supreme Court nominations. But the Republicans and Senator Mitch McConnell made clear that if they take the Senate because of the November 2024 elections in January of 2025, they're not going to, in the January 22 elections in January of 2023, they're not going to confirm anyone that Biden would appoint. So Stephen Breyer is 83. If he wants someone with his values and views to take place, now is the time for him to step down. I think I can do one more question. And I realized, now said there's 13 more that I didn't get to. Does the court ever take opinions of the public into consideration to make judgments? For example, in Roe versus Wade, it seems there's a very high percentage of people in this country would keep Roe. The justices live in society. They know the pressures that exist in society. And so I'm not going to say that public pressure plays no role. I think public attitudes often play a role. But it's been core to conservative ideology since 1973 that Roe was wrongly decided. There's now a majority on the court who believe Roe was wrongly decided. I don't think public opinion is going to play the slightest role in saving Roe versus Wade.
Erwin, I gather we're out of time.
I need to go at 4:30. I'm sorry. I have another meeting.
We appreciate your taking a full hour and a half with us. It's really a pleasure to have you here. I want to remind people once more, the name of the book, Presumed Guilty, How the Supreme Court Empowered the Police and Subverted Civil Rights. I'm going to say, Erwin, we look forward to seeing you again here at OLLI in the near future, and certainly once the court closes up in June or July, I hope we'll be able to get a roundup of the year's events.
I think that would be wonderful. I'd be delighted to do it. And for those people whose questions I didn't get to, and I see 15 of them here, I'll be glad to take your questions next time I come.
Very good. Okay, they'll still be there, I'm sure. Thanks very much. And thanks to all of you for joining us. It's been a great hour and a half together. See you again soon.